Hello, my name is Josh Blackman, and I'm the president of the Harlan Institute. It's my honor to welcome you to the Harlan Institute Ashbrook Virtual Supreme Court competition. This is the Elite 8 round. These are the top 18 participating this year, and we're mooting the case of Torres versus Madrid. We have two excellent teams with us today. For the petitioners from bases Peoria, Arizona, we have Senou and we have Ayaan. And for the respondents, we have from Frisco, Texas, Anita and Kashish, and they'll be arguing Torres versus Madrid. And I'm happy to introduce our three judges. Presiding today will be Rebecca Tableson from the Department of Justice, my colleague Amanda Peters from the South Texas College of Law, and Josh Kastenberg, who is at the University of New Mexico. Okay, without further ado, Rebecca Tableson, Chief Justice. Madam Chief Justice, would you like to time everyone in?
Absolutely. We will be hearing argument in the first case and the only case today, Torres against Madrid. And we'll hear argument from the petitioners first. Josh, should the respondents turn their videos off, or how do you want to proceed?
Yes, thank you for reminding me. When the petitioners are up, if respondents, just turn off your cameras, and then I'll be turning my camera off as well. Okay, whenever you're ready.
Okay, the petitioners, you may proceed.
Madam Chief Justice, and may it please the court. On July 15th, 2014, petitioner Roxanne Torres had parked her car at an apartment complex. Respondents approached and attempted to open the driver's side door of Ms. Torres's vehicle while she was seated inside. Believing that respondents were armed carjackers, Ms. Torres drove forward to escape. As she drove forward, respondents fired on her car, and two of the bullets hit her in the back, temporarily paralyzing her left arm. Ms. Torres sued respondents for violating by shooting her in the back for Fourth Amendment rights to be free from unreasonable seizures. The district court granted summary judgment for the respondents on the basis that Torres was never seized, and she could not bring an excessive force suit under the Fourth Amendment. The 10th Circuit affirmed the district court decision, and neither court addressed the question of reasonableness.
Using the court's past precedent to guide its analysis, this court will find that the unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment. The requirements for a physical force seizure can be explained through three cases. Number one, Terry v. Ohio, two, Broward v. County of Inyo, and three, California v. Hodari. The court recognized in Terry that a seizure occurs only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen. As outlined by the court's ruling in Broward, to constitute a seizure by means of physical force, the physical force must be intentionally applied to the suspect. And lastly, Hodari D. clarified using common law from the time of the founding that the clear line between a physical force seizure and a show of authority seizure was the presence of the mere grasping or application of physical force with lawful authority. In the case before the court, respondents applied physical force to petitioner with the intent to restrain her freedom of movement. The bullets they fired were an application of physical force to restrain movement because they were intended to terminate petitioner's ability to drive her car, because they resulted in a wound that paralyzed her left arm.
Counsel, how, as a matter of plain English, can the word seizure cover a situation in which the police never have any control over the suspect?
Of course, Your Honor. In this case before the court, since we are dealing with the Fourth Amendment, something written during the founding era, the bar that we look to for the definition of a seizure should be what was understood to be a seizure at the time of the founding. And so regardless of how we define a seizure today, at the time of the founding and in that common law of arrest, which the word seizure activates, the application of physical force, even if it's unsuccessful, is still a seizure. The respondents do actually ignore most of this common law. The only common law source they bring up is the seizing of the charming ship Sally, but we're dealing with the seizure of a person. And so with the seizure of a person, which can be seen like the Massachusetts Declaration of Rights, which equates a seizure of a person to an arrest, and other common law sources show that that's what's activated. And when that's activated, we see in cases like Jenner v. Sparks that the touch of the suspect is enough to raise the bar to it being a seizure.
Didn't all of those common law cases arise in a very different legal context, concerning I think it was, debtors trying to flee from creditors, rather than the police shooting a suspect like this case?
Yes, because and part of it is because they did not have firearms at the time. However, there are cases where, like for instance, Whitehead v. Keyes, which occurred in Massachusetts, in the Massachusetts common law, I believe in the 1800s, and they had a partially codified police law enforcement at the time. And still in that case, they found that the laying of hands was enough to constitute a seizure. So it's spanning quite a long time that this has been the common law in that general area of history, of legal history.
Counsel, I have a question. In your brief on pages 2 and 3, you said that Hodari recognizes that the mere grasping or application of physical force with lawful authority, whether or not is succeeded in subduing the arrestee, was sufficient. In this case, we don't really have the officers acting with lawful authority because she wasn't the subject of their arrest warrant. She didn't even fit the description of who they were looking for. She had not committed any kind of crime in their presence. They really didn't have a reasonable suspicion to approach her. So does the fact that they were acting without legal authority affect your application of Hodari?
No, Your Honor. As we can look to Brower v. County of Inyo with the specific intent requirement, stating that there must be through means intentionally applied, an application of physical force in order to effectuate a physical force seizure. Through our use of Hodari D in our brief, we outline the distinction really between physical force seizures and show of authority seizures. So in this case today, Roxanne Torres, petitioner, shot by respondents in a manner to restrain her movement.
Are you guys frozen too?
Yeah, they're frozen.
Oh, there we go. I think you guys are back.
Okay.
Okay.
Yes.
Just go back a sentence, I think. I think we just lost you for one sentence.
Okay. I think you're saying that the grasping is still because it's a.
Yes, Your Honor. Through the Brower requirement, what's outlined is the intent. And when we use Hodari, we use the distinction between show of authority and physical force to outline what occurs in this case today. In this case, Petitioner Torres was shot in the back twice, a clear intrusion of her Fourth Amendment rights. And so that activates the Fourth Amendment. And the mere grasping or application of physical force through means intentionally applied had occurred. And you can look to the joint appendix to see that respondents shot Torres in a manner to stop her movement.
And just to add on to my counsel's answer, when they effectuated this seizure, the respondents were in their tactical police vests. They were acting under the color of the law because they were there to execute a warrant. They were trying to stop Torres to investigate and see why she was there. So they were acting within their lawful. They were acting under the color of the law.
Counsel, I'd like to just jump back for just clarification for myself. You said that the fact that the police officer shot her is evidence that they intended to stop her. But according to your analysis, should it even matter whether the bullets connected or if they fired a warning shot over her head and not intended to hit her, but intended to get her to stop? Isn't that what you're going? Is that what you're going for?
Well, Your Honor, in terms of a physical force seizure, and that's what's occurring in this case today, we look to common law to see that the mere grasping or application of physical force with lawful authority is enough to effectuate a seizure. So in terms of this case today, that shot by by respondents was the application of physical force being used through means intentionally applied to stop petitioner's movement.
And just to add on to that, Your Honor, the firing a warning shot, like over petitioner's head, would be construed as a show of authority, because that's the police saying, "We're here, we want you to stop." That's equivalent to telling somebody, stop moving. However, as we see in not only the common law, and this is actually very similar to even the case Jenner v. Sparks, where the police told the person to stop, but they didn't. So you can fire, if the police fired a warning shot and she did not stop, there would be no seizure. There would be no submission to authority, which is the test from Hodari. However, the bullet actually connected with her, it hit her, it violated her bodily integrity. And so because of that, there has been physical force applied to her body, and so there must be a seizure.
What about a tap on the shoulder or an officer shaking someone's hand? Under your test, would those be seizures?
Okay. No, those would not be. And the precedent that we can look to for that is INS v. Delgado. In this case, you had a group of immigration officers who were asking questions at a factory, and they were tapping people on the shoulder to get their attention. In that case, that tap was not enough. It was not intended to seize. It was intended to get the person's attention. And so because of that, that activates the Mendenhall test, which says that you must, if you are free to leave, then there has been no seizure. So that is a show of authority, not physical force, because it's not intended to seize the person. And so because of that, those cases that you were describing, Your Honor, those would not be seizures, those are consensual. And so that would not be a physical force seizure at all.
Yeah.
And Your Honor, I'd like to add on that ruling for respondents goes against the founder's intention, as it sacrifices individual rights for government. The framers aim to protect the people from government officers, and this protection cannot only activate once the suspect is within custody of the officer, nor should that protection be removed if a suspect flees. We pray that you rule in favor of petition.
Thank you, counsel. I think now if you guys can turn your video off, and we will switch to turning the respondents' videos on. Thank you, guys. Okay, let's just wait until the timer is set. I guess I'm not sure exactly. There we go. You may proceed, counsel. Thank you.
Madam Chief Justice, and may it please the court. My name is Kashish Bastola, and my co-counsel Anita, Ashok, and I represent the respondents in today's case. Your Honor, the question presented before the court today is whether an unsuccessful attempt to detain a suspect by use of physical force constitutes a seizure within the meaning of the Fourth Amendment, or must physical force be successful in detaining a suspect to constitute a seizure?
Since the founding generation, the court has recognized the Fourth Amendment term seizure to mean intentionally taking possession, custody, or control of a person. We look to past precedents such as Brennan v. California, Broward v. County of Inyo, and Terry v. Ohio, along with multiple dictionary definitions from Samuel Johnson's 1755 dictionary to the modern 2014 Merriam-Webster dictionary, all of which reiterate that a successful seizure only takes place when a suspect is taken under the control of the authority, and their freedom of movement has been terminated. Additionally, it is important to understand the stark differences between the case of California v. Hodari D. and the case presented before us today, as the language in Hodari D., specifically cited by the petitioner, is in fact dicta and should have no bearing on this case. And finally, we ask the court to consider the repercussions of ruling in favor of the petitioner, since this would directly hinder the ability of police officers to fulfill their duty of serving and protecting the people. This ruling would also blur the line between an attempted seizure, a successful seizure, and an unreasonable seizure.
Now, petitioner cites common law purporting that ancient English common law should control this case and serve as the fundamental definition of a seizure. However, this court does not function on the authority of common law. Instead, it examines common law for mere historical context. In Justice Breyer's, in his concurring opinion of Wyoming versus Houghton, another Fourth Amendment question before this court, Justice Breyer noted that history is meant to inform, but not automatically to determine the answer to a Fourth Amendment question. And even tracing back to the Judiciary Act of 1789, it's evident that several limitations exist when we're interpreting common law at both the federal and state levels. And so instead of relying on such an outdated and narrow definition of a seizure from a time when armed municipal police departments did not even exist, we asked the court to use the definition of a seizure that was introduced with Terry versus Ohio, and again used in more recent cases such as Broward versus County of Inyo, as well as Brennan versus California.
I'd like to ask you some questions about Hodari D. I know that you indicated that in your view, the relevant language is dicta, but You would agree, wouldn't you, that Hodari D, whether it's dicta or not, really addresses head on the question that we're facing in this case?
Yes, is a question whether the question presented before the court in Hodari addresses exactly the type of seizure we're handling today? Sorry, could you?
Well, I guess my question is, it seems to me when I read Hodari D, I found in that decision the answer to the question we're facing today. And I'd like you to, do you agree with that?
Your Honor, we no matter what the ruling or what was held in Hodari, we don't believe that that should be relevant in this case at all. Since it is dicta, and even if it wasn't dicta, we still believe that there are other precedents which set out a clearer definition of what a seizure is, especially since when we're looking at Hodari and when we're looking at Justice Scalia's opinion, we can see that a lot of the reasoning from the court was derived from common law, from the common law definition of a seizure, even though common law was not directly referenced in the holding. However, I believe that when we're examining that definition of a seizure, we should, and when we're examining how to use Hodari in this case, in the context of this specific question, we do have to look back to the origins of the Fourth Amendment and the nature in which the Fourth Amendment was brought up in this nation. When we look back to the general warrants, which existed under English common law and the writs of assistance, as well as how our founding fathers responded to the writs of assistance in order to protect individual liberties and to protect individual freedoms, we see that our Fourth Amendment and the search and seizure clause of several state constitutions, and I also remember the Delaware Declaration of Rights, they derive their search and seizure language to protect the personal liberties, as well as to limit the definition of a seizure. And what petitioner is seeking to do is to expand on that definition of the Fourth Amendment seizure to incorporate a mere touch, to incorporate means intentionally applied, which should not, it's inappropriate, since the Fourth Amendment is not, should not be used beyond the scope that it was intended to be used by our founding fathers.
And Your Honor, if I may add, we placed more heavy weight on other precedent cases, such as Terry v. Ohio, Broward v. County of Inyo, and Brennan v. California. In Terry v. Ohio, they described the original definition of a seizure. And the court ruled that whenever a police officer accosts an individual and restrains his freedom to walk away, he has then seized the person. Meaning that when the police officer has restricted and terminated the suspect's freedom of movement, that is when a seizure has taken place. And we see this again brought up in Broward v. County of Inyo, where the question presented before the court was whether a police roadblock constituted an illegal seizure. And the court ruled that a Fourth Amendment violation requires that the police acquire physical control of a person's or possessions. And in the case presented today, the police did not obtain physical control of Torres. She was able to flee over 75 miles, meaning that she maintained her freedom of movement and escaped from under the custody of the authority. And then finally, we look to Brennan v. California, which also highlights that a termination of freedom of movement is needed for a seizure to take place.
But counsel, what you're arguing is that, and correct me if I'm wrong, but you're arguing that restriction of freedom of movement has to be instantaneous in order for a seizure to take place, correct? In other words, you made the very good point that the individual drove several miles away. But if you're looking at a geographic and time-space test, it seems to me what you're arguing is that once a person can flee, the seizure's over under any circumstances.
Yes, Your Honor, that is what we're saying, that a termination of freedom of movement needs to be there in order to constitute a seizure. But that termination of freedom of movement does not necessarily have to take place as soon as the shots were fired. I think it would be reasonable to say that, let's say that Torres was able to travel another couple hundred feet, but her freedom of movement was then terminated. That provides a reasonable distance and a reasonable amount of time for officers who, keep in mind, were on foot while Torres was in her vehicle to get to the petitioner and to take the suspect into custody. So that seizure does not need to take place or the termination of freedom of movement does not need to take place instantaneously, but as soon as the suspect's freedom of movement is terminated is when a seizure takes place.
Yes, and just adding on to what my co-counsel was referencing to with Terry versus Ohio, petitioner uses Terry versus Ohio to support their definition of a seizure. However, we have to look at what was actually held in Terry versus Ohio, which is that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person within the meaning of the Fourth Amendment. So the petitioner might be referencing to reasoning that the court used in Terry versus Ohio, but the definition that was set out by Terry versus Ohio is one of our most recent examples. And it's also a consistent and recurring definition that this court has used in similar questions before it, such as today. So it's really important to understand that that there must be a complete termination or restraint to the freedom of movement by a suspect in order for there to be an actual seizure constituted under the jurisprudence of the Fourth Amendment.
Counsel, in your brief, you focus a lot on all of the things Ms. Torres did after, sometimes like days after she was shot. But the Fourth Amendment requires that we look at things at the moment of the intrusion, and things that happen later don't really justify what happened at the moment of the intrusion. So why do these facts that occurred after she was shot matter to you legally? What's your best case to show that that's okay for this court to extend the analysis beyond the moment of intrusion?
Well, Your Honor, we look to the case of Brooks v. Gainesville, which highlights that the use of physical force alone is not enough to constitute a seizure. And so, as the petitioners argued that the moment that the bullet struck Torres was when she was seized. However, what we are arguing is that physical force alone is not enough to constitute a seizure. And so we have to look to the events that occurred after that. The fact that Torres was able to flee from the grasp of the officers. That is a very important distinction to make because her freedom of movement was not terminated.
And adding on to what my co-counsel just mentioned, we also look to an appeal, the Josefa Segunda from 1825, which does involve maritime law and does regard a seizure of an object or property. However, we believe that is directly connected to the events of this case at hand currently, since it deals with a fleeing vessel and the seizure of a fleeing vessel, similar to how respondents in this case were dealing with a fleeing suspect in a fleeing vehicle. So looking at that appeal, looking at the Josefa Segunda, we can see that when a vessel or a suspect in this case is able to escape control and is able to transport herself over 75 miles away from respondents without any restraint to her movement, regardless of a paralyzed arm or whatever injuries or whatever effect the gunshot from the respondents may have had on her, we must see that there was no termination of movement or restraint to her movement. Therefore, there was no seizure under the Fourth Amendment.
Counsel, I know that you've urged this court not to look to common law in resolving this case, but we do quite often look to common law, and let's just assume I want to here. What do you think are the best common law sources supporting your rule? How should we analyze that from your perspective?
Yes, Your Honor. If going off of what my co-counsel just said about the Josefa Segunda, that would probably be our most widely used source of common law that supports our case. However, we also look to dictionary definitions of the term seizure. We look to Samuel Johnson's dictionary from 1755, which defines seizure as the act of taking forcible possession. And the word possession is the most important in this definition. Because Torres was not taken into possession by the authority, she was not seized. And we see this definition remaining consistent throughout history. As we look to the Merriam-Webster's dictionary of 2014, their definition of seizure is the taking possession of a person's or property by legal process. And so we see that the term possession, the idea that the suspect needs to be taken under the authority, the control of the authority, is what constitutes a seizure under the jurisprudence of the Fourth Amendment.
Counsel, I appreciate your arguments, in particular your reference to Samuel Johnson's dictionary in regard to the common law question. Would you prefer the court give Samuel Johnson's dictionary precedence because it actually does have a definition over common law maritime case law?
Go ahead.
Yes, Your Honor. We do believe that the definition in Samuel Johnson's dictionary does provide a clear definition of a seizure, especially since it is during the common law time period. And again, relating back to the general warrants issue and the issue with the writs of assistance, we see that common law, which that common law which is associated with the writs of assistance, stands directly opposed to the purpose of our Fourth Amendment. Our Fourth Amendment was, created to protect individual liberties and to protect an abusive federal government. So when we're looking at and when we're examining common law, and when we look at the writs of assistance, we must understand that the writs of assistance stands, and that common law from the writs of assistance stands against our the Fourth Amendment.
So, Your Honor, affirming the 10th Circuit's court's ruling does not exchange private interests for public interests, as the police, the state, and the US Constitution all serve to protect personal liberties. Instead, ruling in favor of the petitioner would risk the duties of the officers to become obsolete, and it would blur the lines between an attempted seizure and a successful seizure within the jurisprudence of the Fourth Amendment. Therefore, we urge the court to uphold the ruling of the 10th Circuit Court in all respects. Thank you.
Thank you, counsel.
Thank you.
At this point, I believe the petitioners have reserved a few minutes for rebuttal.
Yes, Your Honor.
Thank you.
Yes.
Okay, you may proceed.
Madam Chief Justice, and may it please the court, in our response, we will cover three things. First, the common law definition of a seizure, then past precedents, and finally, the government administrability of this case. First, I'd like to start out with the response to the definition they put forth from Samuel Johnson. As I agree with them, the Samuel Johnson Dictionary is a good metric for what a seizure was at the time of the founding. Published in 1785, it's right around the same time. However, I do disagree with their hand-picked definition of a seizure, and I respond with my own definition of seizure, which is from the dictionary, which is an arrest defining an arrest as any seizure of the person. And that phrase, seizure of the person, is the exact same phrase we see in the Constitution. And by using that definition, an arrest as a seizure of a person from Samuel Johnson's dictionary, it is obvious that those two things are implicate each other. Secondly, I'd like to discuss the judicial act that they reference. That judicial act only applies to district courts. They actually excluded that part from their quote, but the full quote reads that the district court shall have, at the beginning, it reads that the district courts shall have exclusivity of the courts of the several states. And part of that long paragraph about the judicial courts is the common law, how to use common law that they reference. So that doesn't even relate to this case. This is the Supreme Court, so that doesn't apply. Next, I can talk about the fact that they talk about Hodari as dicta. Hodari is not dicta in the way that we use it for two reasons. Primarily, first, because we use it to say that a show of authority seizure is distinct from a physical force seizure. They're completely different, which is something that was part of the Hodari's ruling. Secondly, we use it to say that the grasping is what activates a physical force seizure, and that's the line between them. That is not dicta. That was used in Hodari because they were trying to say whether or not the Hodari D, the boy, was seized when he tossed away the crack cocaine. Finally, the Hodari decision does talk about the whether or not successful or not, but we have enough common law to support that. And so Hodari uses that common law, it dips its foot in that common law, we go into it further. And so because of that, that part of the case does not carry over. Also, it is interesting to see that in their brief, they do ask this court to overrule Hodari, which is confusing to me because they also say that it's dicta. So we do want the court to stay with stare decisis, not to overrule past cases without a very good reason. In this case, we do have a reason to keep the past precedent, no reason to overrule it. Lastly, talking about attempted seizures. In their case that they reference in their brief, Sacramento v. County of Lewis, it talks about an attempted show of authority seizure. a police officer was having his lights on, trying to chase a suspect, but lost control of his vehicle and crashed into the suspect. So there was a physical force seizure, but it was not intended. The police officer did not intend to crash into the suspect. So it was.
Does your rule make it difficult for police officers to do their jobs?
It will not. Actually, ruling for respondents, Your Honor, will make it a bit more difficult because they want the metric to be whether or not the suspect stops, whether or not the suspect chooses to stop. And so that means every single situation that an officer goes into, what the suspect does is going to affect whether or not a seizure occurs. They don't really know whether or not a seizure is going to happen if they shoot a suspect, because if they decide to stop or if they're Superman and they run away, it's different. Our rule, our analysis is much more easier to apply, Your Honor, because it is objective. It has to be the objective intent, has to be the physical force means, and that's enough for there to be a seizure. It's very clear. An officer will be able to decide before they're even in that situation whether or not a seizure will be implicated if they shoot the suspect.
Additionally, Your Honor, to go through the three cases that respondents cite, Terry v. Ohio, Broward v. California, and Brennan v. California. What we need to understand is the principal question asked in each of these cases. If we look to Broward v. California, the principal question asked was the intent, whether intent was necessary for a physical force seizure to occur, not whether the detention of a person was indispensable or not for a seizure. And so at that point, Broward, the suspect, had died, so there was no contest. So that actually supports our case because it shows through means intentionally applied. Any physical force through the mere grasping or application of physical hands with lawful authority can be effectuated as a seizure. Similarly, in Brennan, there was a show of authority and that person submitted to a show of authority. Therefore, there was no seizure. We're focusing on physical force. And Terry v. Ohio finally creates the distinction between physical force and show of authority, which we outline in Hodari. We pray that you rule in favor of petitioner, and thank you for having us.
Thank you, counsel. The case is submitted.
Wow, that was.
Hey, Josh, can I just say something?
Go ahead, my friend, the other Josh, as we call him.
The other Josh, the older Josh.
The smarter Josh.
No, not at all. Josh and I go back a long way, actually. You didn't know, it's been over a decade, longer, 15 years, I think.
15, yeah.
Yeah. To both parties, I've done moot court judging, and I was in moot court 94. For both parties, that was the most impressive argument I've heard from both sides. That was phenomenal. It's tough to pick a winner, so I'm not going to. I'm just going to add in scores. But I also served as a judge for 7 years, and I wish counsel could think on their feet like the four of you did. You are ready to argue big time, so good on you.
And by the way, I've known Josh since the mid 2000s when you guys were in kindergarten, I suppose. We worked at the Department of Defense together for a couple of years, and he was a judge advocate general for a number of years. He serves as both a prosecutor, as both a criminal defense, and as well as a judge. My good friend Amanda was a prosecutor here in Texas for a number of years. Rebecca, who's blushing, she actually argued the case before the Supreme Court. So take their comments seriously. Amanda, Rebecca, either one, if you want to get some feedback for the kids. These kids, they're adults, they're not kids.
No, I was a prosecutor and defense attorney, and I also did appellate work, and I did oral argument myself. And one of the things that I do every year, because I teach legal research and writing some level criminal law classes at the school that Professor Blackman and I teach at, is we do oral arguments, and you guys do better than my law students do. And so I want to tell you that one of the things that I think is really important is that there's a few things when I'm looking at moot court, and that is that you answer the questions asked, which you guys did. And there are some lawyers that try to kind of dodge, but you did a good job of answering the questions. And the other thing is, I think you always have to remember that it's really not about you, it's about the court. And they're asking you to come to answer questions because they have concerns. And so you did a good job of kind of recognizing that we had concerns and addressing those. The other thing that I will say is that it's really hard to kind of go seamlessly between answering questions and back and forth to your presentation. And you guys did that like pros. And so all of you should be, and the last thing is that you guys all have beautiful voices. gosh, I could listen to audiobooks with all of your voices. They're just gorgeous radio type voices. So that makes it easy for us to kind of listen to what you have to say. So you did a great job. And you were very prepared on legal issues that are really complex. I mean, this is hard. So you guys did a great job.
Yeah, I agree with everything Josh and Amanda have said. Congratulations. This is really an accomplishment. You know, a lot of, like, Josh and Amanda have touched a lot on your presentation skills and the sort of smoothness with which you answered questions directly, switched between the two of you, pivoted from answering questions to moving back to your argument. And I agree with all that. So I'll just say, like, I know a good bit about this case, and I was really impressed with your substantive knowledge as well. I mean, like, there are a lot of different bodies of law that are relevant here. There's the constitutional Fourth Amendment source of law, there's common law, there are like various things the court has said in different contexts about what a seizure is over the last 100 years. And you had a mastery of all of those, and you marshaled them really well. And I mean, I was just like, you know, dropping cases like, you know, Jenner against Sparks, or, you know, the Josefa Segunda, like, and the Samuel Johnson dictionary. I mean, that's good. Like, that was really, really impressive. You guys got a lot of hard questions that the Supreme Court justices actually asked the advocates during the Torres versus Madrid argument, and you answered them like right on point with the relevant law. So yeah, so not only was I impressed with your presentation, but I was also really impressed with your substance, especially as people who haven't been to law school. I mean, it was awesome. So congratulations.
I do think, if I can, Josh, quickly give one critique, and take this so nominally. The question, and this is particularly for respondent, the question isn't whether, quote, the police should get away with a shooting, right? The question is, should the Fourth Amendment, and whenever you're faced with a difficult argument, concede that, or make it clear that you're not advocating for someone to get away with anything, or an institution to. You're advocating for the Constitution. I mean, and this is something, you know, this is something that I once argued and was told to me when I was sitting where you are. It's like, I'm not arguing for management. I'm arguing for an act under the Taft-Hartley Act. And so, and for this is critical in this day and age, when you go up and you're going to defend law enforcement, you know what society's pressures are on law enforcement now. So you're not arguing to let anybody get away with anything. It goes back to the point of, you can't use the Fourth Amendment for this, because that goes outside the original intent. There may be other avenues. So that's just a very, very minor point.
That's very useful. Well, let me say, I've been judging this competition now for almost 8 years, and I cannot believe how good these arguments have gotten. I'm truly blown away. This is the first we've done sort of like multiple rounds. So you'll have at least basically 3 bites. You did the preliminary round, you did the semifinals of this Elite Eight. I've never had this many rounds before, and you get better. I've watched each of you, all 4 of you at each stage. I've judged personally every round. I sort of put my camera up, but trust me, I was watching, and you've gotten better, right? You've learned from your opponents. You read your opponent's brief. I can tell Professor Peters is a excellent legal writing professor, my dear colleague. She read your brief. I know she did it. Like and she's like, oh, I'm page 2 and I'm page 3. I'm like, okay, she's good, right? But you read each other's briefs and you responded to each other's, oh, my friend the other side said this, but that is so good because it's on the fly, right? You can't prep that when your friend says something on one side and you respond to it. That can't be taught, right? Well, you can teach it, but it's a skill set that you have to have. Brilliant. One minor critique. This is hard. Professor Peters will agree. Don't use your hands. You want to go 1, 2, 3. Keep your hands off camera. Just keep them at your side. I know you know, I'm from New York. I talk with my hands, but just hands down. Right, Professor Peters? Am I right about that one?
Yes, and one of the things that was really funny about Zoom arguments versus in-person arguments is that this frame is kind of small. Yeah. And so hand gestures just seem so much, your hands seem so big, and you know, it's just weird. So what I would say is, yeah, and if you know that you have nervous habits, like for me, when I'm nervous, I talk faster. So I have to moderate my speech a little bit. I didn't see any of that with you guys, but if you know that you use your hands a lot and they're becoming distracting, of course, when you're in person, you can grasp the podium and kind of control that. But I think in this forum with Zoom, just those kind of movements even seem exaggerated.
Yeah. And even the mask on, mask off, that was a complexity which no one's ever done before. That was impressive. Mask on, wax on, wax off, right? You were just very, don't get the reference, but it's just very, Karate Kid, you've seen it, Cobra Kai probably, right? Yeah, they're okay, I know. But just the fact that Anita and Kashish are in different locations and you just hand it seamlessly from one to the next one, that's a skill set that no generation's ever had to do before. That's like a new thing from the last year, that you have oral argument with location A and location B and seamlessly handing off. That's impressive. And my hats are off to all of you. We're gonna have a hard decision because all the 8 teams that have advanced are all good enough to be in the final round. It's going to be decided by decimal points. It's going to be pretty close. But we're going to have a championship round at some point, probably later this month. We'll email your teacher on Monday, or we have another round tomorrow and Sunday. So either by Sunday evening or Monday morning, we'll have these final scores announced. But no matter what happens, I want to tell all 4 of you, you could go to a law school tomorrow and win a moot court championship. No, Professor Peters, Professor Kassenberg, we're both professors. Ms. Tableson, Deputy SG, you could walk into any law school tomorrow and win a championship tomorrow. I mean that sincerely. It's just remarkable. And you'll have my information. If you want to email me with questions, I can throw them to Josh or Amanda or Rebecca about law school. Or if you have questions for us, if you guys have a few minutes for the judges, any questions for us you want to ask? Please just take this chance, because it's we're here, we're on Zoom, and if you have any questions for us.
Yeah, I mean, I guess I have like a question. So I know like we're still pretty young. I know I'm 16, Anita's 17. So like we're still, I guess, like we have a long time to go. And personally, I do want to work in like the federal judiciary. So I was just wondering what steps you would like recommend taking right now at an early age to like, I guess, build on connections and build on the expertise and knowledge that you would need to have. Like, is this the right forum or like the right place to be taking in that knowledge to get to where I want to be, I guess?
Oh yeah, Josh, Rebecca, Amanda, whoever wants to answer that, please.
I would say it's never too young to volunteer at an office. Now, I don't know whether the local U.S. attorney offices are taking high school students. They will take undergrads. I don't know if they have an 18-year-old, an 18 cutoff, but I know, for example, our district attorney office has a high school program, and the state attorney general does as well. And so I would say, I know that being a high school student has so many competing interests to them. I mean, I have a high school junior as a son, and I get that. And sometimes the thing before you is, do I do a job that pays or do I do an internship? And I understand that too, but I think that it's never too early to get involved in that. And I think in particular, when you go to your undergrad institutions, you'll have doors opening for you to do internships, and jump at those.
Thank you.
Say that between now and you becoming a federal judge, if that's your ultimate goal, college, you have to go to law school, you have to be a lawyer, and then you have years of practice before you can even possibly get to the bench. So the most important things, I think, are to kind of figure out what you want to do in the now, because it's really easy for us to focus on the future, many, many years ago or in the future, but we really got to focus on the now. And I think for me, the moment that I wanted to be a lawyer, my dad was in federal law enforcement, and I heard that kind of talk every night. It sounded exciting to me. I wanted to be an assistant U.S. attorney because all of his friends were assistant U.S. attorneys, and those are the people I knew. And then, so I wanted to be a prosecutor, and that's what drove me to go to law school ultimately, and even through college. But I majored in something I wanted to major in, which was technical writing, because I love to write. And that actually helped me in law school, and it's become my career. But one of the things that I would say is that I did an internship at the U.S. Attorney, the Federal Public Defender's Office, and learned I don't really want to work for the feds. I'd rather work in a state system. I didn't really like the federal system as much as I thought I would. I also learned that I could do defense as well as prosecution. Through a lot of internships, I ended up in Harris County, which is in Houston, and I loved it. And so I think what you need to do, and I never thought I'd be a professor. So what I would suggest is that you kind of just go through life, and maybe it takes you there. Maybe you have some interesting adventures in the meantime. Maybe you end up getting into a field that you never imagined. But I think that obviously all of you have skills to go to law school if that's what you choose to do. But we all have different paths that kind of brought us here, and some sidetracks that we didn't expect to take probably. And those are as much fun as the end result, honestly.
Thank you so much. Yeah, and I'm actually in Collin County. We're both in Collin County in North Texas. So yeah, I think.
Oh, I know a judge in Collin County. Email me later. Judge Miskell, I know her. Just email me later. She's right there and right now where you are. Okay, email me.
Thank you. Yeah, but yeah,
Here,
of that.
I'll put my email in the chat just so you have. I do know a judge here who's very. She actually just won State Judge of the Year award because she was the first judge in Texas to have a Zoom trial. She actually did a jury trial with Zoom, which, I mean, who would think you have to do that? But you have to do that.
Let me make a comment if I can too, Josh, or 2 comments on state judges. States still do trials in the criminal arena. There aren't many federal criminal trials. They plead out. And my mentor was the first assistant U.S. attorney for the Western District of Missouri. And he went 14 years without a litigated trial before he retired because everything pleads out. And in the state, you will get one litigate, so you'll get to see those. And just really quickly before I have to go, my interest in becoming a lawyer was a little bit of a different path. My dad was a physics professor at Berkeley, and he was asked to serve as a one of 2 lead investigators on something that seems like ancient history now, known as 3 Mile Island. We had a nuclear power plant mishap. So we packed up from the Bay Area and moved to Maryland. And I saw the Senate. My dad was doing an independent investigation on behalf of the Department of Energy, and he wasn't partisan to, Babcock and Wilcox that built the reactor, and he wasn't partisan to Jane Fonda and her anti-nuclear group. He was just trying to get to the answers. And I saw senators try to shred my dad apart in a very unkind way, seeking ulterior motives. If you know anything about scientists, they have a problem in front of them and they try to solve it. That was my whole dad's life. But I saw the NRC's lawyers defend my dad finally, and I thought that's what I wanted to do. So
it's a good story. Rebecca, you want to just talk about your experience? She's modest as anything, but she said she's had a pretty good career in the law so far.
My dad was a law professor, like everyone, like
my law
Amanda,
professor.
Josh, and Josh.
Her dad was my
Josh
law professor,
Blackman.
one of the best ever had, Michael Krause.
So I can't say that like I take too much creative credit for wanting to be a lawyer. Like my dad been talking with the law for a long time, but yeah, I did. I went to law school and I did a couple clerkships, which were really wonderful in helping me sort of figure out
with Judge Kavanaugh and Justice Scalia.
Yes. Those are really helpful in helping me figure out what I liked, because you see a whole different range of legal issues that come up to the court, and you get to approach them as like not advocating for one client or the other, but as the judge, just reflecting on them objectively. And I loved that clerkship experience. If you do go to law school, that was really educational for me. And then I was at a private law firm for a while, which was a great experience and also paid off a lot of my really heavy loans. And then I'm a prosecutor. I'm a federal prosecutor in Milwaukee, Wisconsin. But for the last year and a half, I've been on a loan to the Office of the Solicitor General, which is a little office in Washington, D.C. that handles all Supreme Court litigation for the United States government. And I've been learning like a huge amount there. And, it's very, I'll just say, it's cool to work for the government in different ways. Like as a prosecutor, trying to put, what your prosecutor does, trying to prosecute crimes. But then also now, like as a lawyer and Main Justice, you can see that there are ways to represent the people, whether it's a state government or the people of the United States, in all sorts of different ways, like to advocate for the interests of the government and for its citizens in like making sure that the government follows the law and in staking out positions at the Supreme Court. So I found public service and government service to be really rewarding. And there's like a lot of different ways you can pursue it depending on your particular interests. So, and just generally, I think the law is more broadly, even outside government service, it's such a big, diverse field in which you can find so many different paths that like appeal to you. I mean, I'm not at all a commercial litigator or a commercial lawyer. I would never know how to do a merger or an acquisition, but that's like a whole other thing that people love. So if you do get into it, like you'll find your path and you'll find your people.
Thank you.
That's
so
awesome. Any other questions from Ayaan or Senou? Do you want to ask the judges?
Yes, actually. I guess this is kind of a question for Mr. Kastenberg. Senou and I go to a very STEM-oriented school, and so it's a little difficult sometimes to get into a lot of law and government and humanities, and like the passions that we hold about public policy and the space in which government like works sometimes is hard to find when we go to such a STEM-oriented environment. I was wondering, is there a way to connect maybe what we do here with the Harlan Court and with our scientific knowledge in general?
You know, I've come to learn this only recently. I used to look at patent lawyers and patent law firms as kind of being an adjunct to the tech world. What I've come to realize in working with our adjuncts who are lawyers for Los Alamos National Labs and Sandia, that a lot of what they're arguing on behalf of the government is policy and national security. You know, I'm not if I told you I was a STEM person myself, the truth of it would be I'm kind of locked in I seem to be behind the times by a decade or two these days. But I think that's one area to do is if there were an opportunity to shadow patent lawyers, because you can interlock. The other is anything the Department of Defense does is necessarily, in some regards, STEM oriented, and internships with the DoD when you're in college, particularly those parts of the DoD that are interested in cyber warfare and space, will get you right in the mix of law and technology.
Yeah, I've got just one more. I work all the time with the EPA and the Department of Energy, and actually there are a ton of like lawyer scientists or scientists interested in public policy or lawyers who dabble in science in those agencies, because a lot of their policy decisions are science-based, but then you also need to make sure that they're lawful and that they accord with the policies of the administration. And so there is a lot of that intersection in government work.
Okay.
I have a student who's one of the smartest people I've ever taught, who worked at Sandia Labs as a chemist, a some kind of nano, I don't know, some kind of specialty in chemistry. And he worked there for many, many years and then became a patent officer for the Federal Patent Office, and has done all these internships in federal courts here that need his help and his expertise because the federal judges don't always have that expertise. And there's a lot of people that go work for big firms making big money doing that kind of stuff. So there's a lot of ways that they've touched on, and many more, that you could get into law with that background. There's also medical malpractice and doctors that need to be represented, and patients need to be represented by people that have some kind of scientific and medical background. So there's a lot of different ways that you can do it. And the thing about law school and law is you don't know how varied it is until you get here. Like, who would think there's a whole field of construction law? But there's all kinds of areas of law that I never imagined before I went to law school. So it's kind of cool.
And my background, I did computer science undergrad. That's actually where I met Josh. I started working at the DoD and doing network security many moons ago. And I started to go to law school. I was working at the DoD. I was actually a part-time law student. And I was able to transition to a general counsel office where I met my good friend Josh many, many moons ago. And I was doing employment law. Who knew? But no, that's where they needed me. That's what I did. Anyway, this was fantastic, guys. This was really special. And again, the judging is gonna be tough. I don't know how we're gonna pick the winners, but we're gonna have decimal points separating you all. But I put my email address for you in the chat. You can reach out to me. Definitely the Collin County kids. I know, just email me. I'll be in touch with you. And as well, my friends in Arizona, you're welcome to email me as well if you have any questions, and I can forward questions to Josh, or Amanda, or Rebecca. But this was really special. So let me adjourn, if I can take Rebecca's gavel for a moment. I'll adjourn the recording. The students can sign out. We'll get to the judging part, and we'll be in touch with their teacher soon. Thank you all so much.
Thank you.
Thank you.
Thank you.
Appreciate it.
Thank you
Yeah,
so much.
thank you, Kounouho and Ayaan. That was very fun. I think that was a lot of
Thank
fun.
you. It was great.
Thank you.
Bye-bye, guys.
Hey, Josh, I uploaded my